Okay, so today on Success Over Stress, so essentially, I've got an appeal coming up for one of the evictions that I had. It was here, I guess, a month or so ago, but the tenant appealed it, and so I'm learning a lot. I'm learning a ton about the appeal process for evictions. Even though I've been in the rental property game for about 10 years or so now, this is the first time I've had an appeal. Otherwise, again, I try to do everything by the books, and so my evictions don't end up being appealed because the tenants don't have any grounds to stand on, and neither does this guy. We have a pretty good personal relationship, but the business relationship is also in check. But he, he's just kind of buying himself some time, which, I mean, I get it from a personal perspective. I get it, and from a business perspective, I get that it's not personal. This is just, kind of what he does or what he needs to do. So the eviction process, this is wild. So here in North Carolina, probably similar to a lot of other areas, but I'll speak about North Carolina because they're all different. But when your rent is due on the 1st, late on the 6th. The state of North Carolina gives you 10 days to for the tenant prior to you filing. Right, so on the 11th day, you can go ahead and file for the eviction. And I saw something in the NC legislature. It looked like that they have to give you a court date to be heard within a certain number of days. So I've got to go back and look at that. I'll pull it up here on the computer when I get back home. But I don't think they necessarily go by that. But typically, you get your hearing within about 10 days or so anyway. And then once you're heard, and you're heard in small claims court, so it's a civil suit. Once you're heard, unless you're looking for more than $10,000 or something like that, then you got to do it in district court anyway. But as a civil suit, you're heard by the magistrate, and then from there, the tenant has 10 days to appeal. So on the 11th day, you can go ahead and file for the writ of possession. And when filing for the writ of possession, that's when the sheriff comes out, and I think the sheriff has a certain number of days to lock the tenant out. I think it said it was either 5 or 7. But so the process goes fairly quickly. But if during that appeal time the tenant is able to appeal, then the entire process is put on hold. Now, when I say able to appeal, because they got to do certain things in order to appeal. I think they have to pay what's in arrears. They have to pay the court costs. They got to pay certain things unless the person files as indigent. If they file as indigent, then they don't have to pay what's in arrears. They don't have to pay the court costs, and I think they don't have to pay I think it's an $80 appeal filing fee. They don't have to pay any of that stuff. They just have to pay what the prorated rent will be from that current day up into the next rent due date, which, I mean, it could just be a fraction of what's due, which is what's going on in my case. Now, in small claims court, for the civil suit with the magistrate, you can represent yourself as an LLC. You can represent yourself pro se, PROSE. Obviously, if you are renting properties and you don't have an LLC, you can represent yourself pro se anyway. But when you go over to district court, there's attorneys in there. Everybody needs to be represented by an attorney unless you are again representing an individual. If it's a corporation or an LLC or anything like that, then you need to be represented by counsel. So that's kind of what I wanted to go see today, is see what the process looked like. Just kind of get an understanding of what's going on. Now, in there was probably 10 cases that the judge had on the docket, and out of the 10 cases, the first 4 were represented by legal aid. Now, I think that should tell you something. But I mean, that's kind of another conversation as well. But all of those cases were dismissed voluntarily. I don't know what that says. I wish somebody with legal aid would share with me what that means. Does that mean that a lot of those people are just kind of trying to buy time, and then they move on, and so they dismiss the case because they don't really have any grounds for the case? But the problem with that is the landlord doesn't get paid during this during this holding time while we're waiting for the new hearing date. The landlord doesn't get paid. The court gets paid. I want to say the court gets paid. The tenant, when they file an appeal, they also have to file a rent bond. I think it's a rent bond for a stay of execution. Rent bond stay of execution, something like that. But anyway, so the money stays with the court, and the tenant has to pay every month to the court instead of to the landlord. They pay it to the court. Now, if rent is due on the 1st, then they have to pay to the court by the 1st. And here's the kicker. I thought it had to be by the 1st. Well, I call in and find out that they still have 5 days after the due date to pay the rent. So it's a process. And then what ends up happening is that if they do not make the payment by the within 5 days after the rent is due, then you can file for your writ of possession and go ahead and get the sheriff to have them out. Now, that just gets them out of the property for the time being, because the only thing that they're paying the bond for is to stay. They hadn't dismissed the case. The case hadn't been dismissed or anything like that. So you'll still, as a landlord or as the tenant, you'll still have the case that'll end up coming up sometime in the future. And so you have to end up showing up for that. I don't know when you get into all of the odds and ends of the court case. Like I said, you do have to have counsel, so you've got to make sure that you get an attorney to represent you. And it looked like there were several instances where the attorney was, I guess the attorneys had been contacted, and there had been an agreement made to dissolve or to dismiss the case. That hopefully that's a possibility, but it's just an interesting process. So I guess I'll go back another week and maybe there'll be a more interesting case. I tell you, there was this one case though where the tenants had been there. They had went through the eviction hearing back in June of 23. Now, this is the kicker. It can take an entire year. These appeal hearings are scheduled almost 13 months out. So during that 13 months, if you are a landlord and you're expecting to have those rent payments come in every month so that you can actually pay the note on the property or pay expenses, pay taxes, pay insurance, all that stuff, you're not putting that money in your bank account. So this is something that you really have to consider. So the tenant, they filed for an appeal back in June of last year. And it was interesting. I have to go back and look at the dates, but it was interesting because I think the court date was maybe June the 8th. And so they had 10 days to file the appeal, which I think fell on the Sunday, maybe being June the 18th. Well, Monday was June the 19th. They should have filed the appeal that following business day, but they didn't. The tenants filed the appeal on June the 20th. June the 19th being a holiday, apparently the courts wasn't closed, and so they should have filed it on the 19th. But they filed it on the 20th, and they've been there for more than a year. And on this hearing date, the judge looked at the filing, and she said, well, this was, essentially improperly filed. So she had to dismiss the tenant's case. So I don't know what the tenant what they've been coming up with all this time, getting prepared for the case, knowing that they've got a good case, etc., and then come up to the court date, and then the judge is like, yeah, this is all wrong. You guys shouldn't have even been there all this time, more or less. So at least they got to stay there for a year. Problem is now, unless the landlord is okay with it. Now, keep in mind, the landlord has been without getting rent for a whole year, and the tenant filed an appeal on them, so I'm sure they're stewing. And so, anyway, that's just kind of how I feel right now. Maybe that's not how they feel. So, and if that wasn't the case, then they probably would have dismissed this whole thing anyway, and they just put them back on a new lease. So I doubt that the landlord is going to be like, yeah, it's all right, don't worry about it. But so now that the judge just put in the dismissal of the case due to improper filing or whatever it is, now the landlord is going to go and file the writ of possession and have the sheriff do the lockout. And so now the tenant and his girlfriend or wife have, probably 10 days to be out. Wow, he was out there. He was crying a little bit, and I get it. And I think that's why I like to have a personal relationship with my tenants, because I don't want them to be in that situation. I really do have, I'm empathetic, and I've got a heart. What I do as my business is business. So I've worked with my tenant multiple times, and try to keep them out of eviction court and everything like that. Communication is key, right? But at some point, tenants, they just don't have it, and they can't manifest it. And so at some point, it's time to keep it moving. Oh, there's a hornet out here. All right. Well, that's the end of the saga for today. So out of the 10 cases that are a year out, one, if you have an LLC, you need to make sure that you have counsel in district court. This is for North Carolina. Two, like I said, the majority of those cases were, 5 out of 10 of them were legal aid cases, which they were all dismissed. So I think that, and again, with them being legal aid cases, people filing as indigent, those kind of things, needing assistance, I think it shows that we're talking about a class of a subset of people where their finances are on the lower end of the spectrum. That being said, now we get into the issue. Now we get into landlord versus tenant. Who's the bad guy? Because landlords don't want to have to go through it. They literally, we're supplying housing, yes, but it's a business. It's not a charity. Some folks like myself, hadn't done it in a while, but have charities or participate in charities. Charity is separate from business, and so when you have a tenant, that's why these landlords are going to, you need to have 3 times the amount's rent. You need to have credit score, such and such. You need to have something to lose, because one of the things that allows people to file for indigent as well is if you don't make the money, or you are on, if you're on food stamps, using SNAP and that kind of thing, then automatically you can file as indigent. And when you can file as indigent, again, you don't have to pay the entire amount of money that's due in bulk to file the appeal. So you don't have to file that. You don't have to pay the $80 appeal cost. You don't have to pay the rent in arrears. There's a lot of monies that you don't have to pay when you file as indigent. That makes the bar much lower for people to get over. And so again, that makes sense why a majority of those cases were legal aid cases. And so again, property owners who have properties who they could very well rent to people that are financially insecure or that have financial shortcomings, when they find themselves in these kind of situations, they're not going to do it again. They're not going to do it again. And I mean, my tenant, when I purchased the house years ago, he came with the house. He's an inherited tenant. And like I said, I've been working with him along the way, and so he's been able to make it work. And so I'm not trying to put anybody out, but this time he couldn't make it work. And so, like I say, he doesn't necessarily fit my my typical standards for a tenant in terms of the requirements, but he is an inherited tenant, and didn't want to put him out. So anyway, we do the best we can with what we got, and we try to help those who can't help themselves. And then when we get to the point to where we need a little bit of help, then everybody turns their back on you, right? So there were a few landlords in there for some other cases, and the judge got on them, and she got on them because they were in there essentially representing themselves pro se, or I don't even know that they were trying to represent themselves pro se. I think one guy was, but she told them, you cannot represent yourself pro se in district court. I don't know what anybody else told you. One guy said, well, the magistrate told me, and he gave the name, the magistrate told me that I could. She said, you can't. By case law, you cannot. She said, don't come back in here without counsel. So she gave him a new court date. And then I think another guy, well, I guess it was essentially the same thing. You know me, I'm a bit of a talker. So when all the cases were over, the judge, she turned to me and she said, can I help you with anything? Did we miss something of yours, anything like that? And so I just started chatting with her. We chatted across the courtroom, and she's really nice, but she can't help my case at all, and there's nothing that she could do for it anyway. And she was like, well, don't even tell me anything about your case. But we did chat a bit, and I told her that some of the attorneys mentioned that you can as a private landlord or as a landlord with an LLC, you need to have counsel. But she said, I told her that some attorneys have mentioned that, especially if the tenant ends up defaulting and they end up moving out before the hearing is heard, that I could just come in and if the tenant doesn't show up, then it'll be dismissed. But if they do show up, then I'll just file a motion of continuance or something like that. But and I mentioned that to her, and she said, I'm telling you, she said, if you come in here and the hearing is a year out and you don't have counsel, she said, I'm going to dismiss your case. Essentially, like, don't pull that mess on me, kind of a thing. Which, I don't know. There was one case where the tenant did show up. Now, this was the first hearing date after for the appeal. The tenant did show up. There was some miscommunication about the calendar call, about having the attorney show up for the defendant, or for the plaintiff. The attorney didn't show up, and so they were calling all around trying to find the attorney and everything like that. They finally figured it out. They figured out that when the calendar call was, and I guess the attorney made a request for a calendar date or something or another, but the judge asked the defendant if she was okay with a continuance or moving the date, And she said, no. She said, I'm not. She said, it's already been a long time. There's already been a lot. I don't want to continue this on. But ultimately, the judge did allow for the continuance, moved it to a new date. And I wrote it down in my notes. She said something to the effect of, typically on the first occurrence of that happening or something like that, that they will grant a continuance. And maybe it's because they did have an attorney. Maybe that's the difference. But yeah, she said, like, don't come in here by yourself and ask for a continuance, which is essentially what was granted to the other two gentlemen who came in representing themselves, whether or not they were ignorant to the fact or not of whether or not they should actually or can represent themselves in district court. I don't know. But, and, she doesn't know that, can't prove it either. But, I guess trying to keep order in the court, she was just telling me, it's like, hey, don't do that. So now, the long and short of it is I've got to find an attorney. I've got to find an attorney to represent me unless I can figure out how to get this all taken care of before the hearing date. But I think there was an instance where that one gentleman who was representing himself, he said, all right, Judge, well, if I can find an attorney to where we can come to an agreement and we can have it signed off with a legal aid between myself and the attorney and legal aid, would that suffice where I don't have to come back for the hearing? She said, yeah, that'll be fine. She said, but send it to me. Don't send it to anybody else, because, you guys are already kind of playing these games with represent yourself and that kind of thing. Get an attorney, have an attorney represent you signing the agreement, and I'll accept it, and then you can cancel it. So hopefully that'll be what I'll be able to do before actually getting to the hearing, because again, I'm on the right side of this thing. I keep my books clean. I'm on the right side of this thing, so it's unfortunate that I'll be missing rent on a monthly basis, and that I'll have to incur these legal fees, and that's just something that you gotta have set aside for in your in kind of like not capital expenditures, but your like the expense side, the one-offs for your business. So make sure that you have some consideration for that. I mean, like I said, I've got a number of properties, and I've been at this for 12 years or so, and this is the first time that I've had to do it. I don't say to no fault of my own, because I could have put this guy out a long time ago, just not renewed his lease. But yeah, just be careful that you don't mix, business and pleasure, business and personal. Keep it all business. Keep your books clean, and you'll be all right. So, all right. Well, what have you? This is what I call success over stress. And we've all got plenty of stress, but I'm about to go back to the house in a little bit and do some programming. So catch me on the programming side of things, where I'm trying to find my edge in the market. But real estate is what I do day to day. So, well, whenever I have to, but it's what pays the bills. So anyway, guys, I'm Eric. I'm out. Peace.